that a defendant might be liable for causing a plaintiff to have a child that the plaintiff didn't want to have, or for causing a child to be born which would have preferred not to be born. For example, I say, "Doctor, I'm pregnant and I have German measles. Does that mean I'm going to have a deformed child?" And the doctor says, "Oh, don't worry. German measles won't give you a deformed child. The doctor is wrong, and I give birth to a deformed child. Some jurisdictions allow me to sue the doctor for wrongful birth and allow the child to sue the doctor for wrongful life. That means because of the doctor's negligence, I had a child that I didn't want to have, and so I want damages. Because of the doctor's negligence, a child was born who didn't really want to be born, and so the child wants damages." All right, we have examined all three of the bases of liability that involve fault. We looked at intent, we looked at negligence, we even took a little look at aggravated negligence. We looked at 7 intentional torts so that we could better understand intent as a basis of liability. We looked at the tort called negligence so that we could better understand negligence as a basis of liability. And in connection with the tort called negligence, we looked at proximate cause and damages. Tort concepts that run throughout the law of torts, with the exception of the intentional torts. All the other torts involve proximate cause and damages as well. The only basis of liability that we have left to discuss is liability without fault, also called strict liability. And the most important thing that I can ask you to remember about strict liability is that it is liability that is imposed regardless of fault. Strict liability arguments are not about what the defendant should have done, what the defendant didn't do, what the defendant was supposed to do, what the defendant should have known, what the defendant knew. Strict liability is imposed as a philosophical matter because we believe that there are certain kinds of activities which are dangerous and which should pay their own way. There isn't much else to be said in general about the concept of strict liability except to remind you that if the defendant is engaging in one of those activities for which strict liability is imposed, and the plaintiff wants to collect damages, the plaintiff is going to have to prove not only that the defendant engaged in that activity, but that the defendant's conduct in engaging in that activity was a proximate cause of damage. And we've already discussed proximate cause and damage. So let's take a look at 4 situations in which the law has traditionally imposed strict liability. And we'll talk about a few more when we talk about specific areas of tort liability. But these 4 traditional strict liability situations will give us an opportunity to understand better what strict liability is about. The oldest form of strict liability, and when I say old, it's at least 4,000 years old because it was first mentioned, at least the first record that humans have of its being mentioned, was in the Code of Hammurabi, which was laws of ancient Mesopotamia that were written before the Old Testament. And in the Code of Hammurabi, there are a series of laws that say that if a person owns a wild animal or a domestic animal which the owner knows is likely to do harm, the person who keeps that animal is liable for the harm the animal does without regard to fault. Now, if I keep a horse is a domestic animal, and I've got a nice tame horse, and if it happens that my horse hurts you, and you want to collect from me, you're going to have to show that I committed some fault. Either that I intended for the horse to hurt you, or that I acted unreasonably and that's why the horse hurt you, or that I willfully disregarded an obvious risk with a high probability of harm and that's why the horse hurt you. But that's because a horse is a domestic animal. If I keep a lion, which is a wild animal, and the lion hurts you, all you've got to do to collect from me is prove that I kept the lion and that my keeping the lion was a proximate cause of your harm. You don't have to show that I did anything unreasonable about it. Oh, let's say I kept the lion in the strongest possible cage in the world, and one day somehow the lion managed to escape from the cage and attack you. I'm going to be liable, strictly liable, for keeping a wild animal. And the same rule applies to a domestic animal which I know to have a dangerous propensity. Oh, let's go back to that horse of mine. Suppose that I know that my horse always kicks people who wear red, and you come around wearing red, and the horse kicks you. I wasn't around to stop the horse from kicking you. You came for a visit and the horse kicked you. I may be strictly liable to you because in keeping that horse, which I knew to have a dangerous propensity, it was like keeping a wild animal. So that's a very old, ancient concept of strict liability that applies to the keeper of wild animals. Incidentally, how do you know whether an animal is a wild animal? An animal is a wild animal if it belongs to a species which ordinarily is not kept by human beings without special restraints. So, for example, I may have a very tame lion. Remember Clarence the Cross-Eyed Lion? He was a television star. I may have a very tame lion. Nevertheless, because my lion belongs to a species, that species lion, which cannot usually be kept by humans without special restraint, the lion is a wild animal, no matter how tame my lion happened to be. And if that lion injures you, I'm strictly liable for keeping a wild animal. The second form of strict liability that's been recognized at common law is strict liability for storing a dangerous substance. And you probably have read or will read the case of Rylance against Fletcher. Rylance against Fletcher involved a defendant who kept water in a reservoir, and somehow the water got out of the reservoir and injured the plaintiff. And the plaintiff could not prove that the defendant had done anything unreasonable. But the English court said that the defendant had to pay for the damage anyway, because although water is relatively safe when it's kept in a container, when water escapes from its container, it's likely to do great harm, at least large quantities of water. And the English court said, when a defendant makes a non-natural use of his or her land for storing a substance which is likely to do harm upon its escape, the defendant is strictly liable for harm done by that substance when it escapes. So, if I have a reservoir full of water and you fall into the reservoir and drown, I'm not going to be strictly liable for that. If you want me to be liable, you're going to have to prove fault. But if the water escapes from the reservoir and damages your land or drowns you in your home, I will be strictly liable for that because I used my land in a non-natural manner to store a substance which, although safe when contained, was likely to do great harm upon its escape. Rylance against Fletcher, storage of dangerous substances. A third traditional form of strict liability is imposed upon persons who engage in ultra-hazardous activities. And a fourth form of strict liability is imposed on persons who engage in abnormally dangerous activities. Now, the difference between ultra-hazardous activity and abnormally dangerous activity is really slight. So let's talk about them together for a moment, and then I'll distinguish them. Both are activities which necessarily involve a grave risk of serious harm. A risk that cannot be eliminated by acting reasonably. And activities that are not common. Let's look at those three elements again. An activity that involves a grave risk of serious harm. That's the first element. The second element, which cannot be eliminated by acting reasonably. And the third element, and the activity is not common. Now that's enough to make the activity ultra-hazardous. Some jurisdictions require that the activity be not only ultra-hazardous but abnormally dangerous. And that means they also consider whether the activity is appropriate to the location where it's being conducted. Because, you know, even a dynamite factory might be appropriate in certain locations. So, some jurisdictions impose strict liability upon persons who engage in an ultra-hazardous activity. Once again, grave risk of serious harm that cannot be eliminated by reasonable care, and the activity is not common. Some